One.
Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner. And on behalf of Judge Bennett and Judge McBrayer, we welcome Mr. Dillon and Mr. Miller for this oral argument today, which is being conducted via Zoom technology and broadcast live so that the public may view the hearing as well. We will conduct the hearing in the same manner as if all of us were in the courtroom together, and each of you have 15 minutes to argue, and the appellant has reserved some of his 15 minutes for rebuttal. Unless there are announcements, I will ask Mr. Hibner to call the case.
Khalid Almuawi v. Antwan Gregory.
All right, you have the floor, counsel.
Good morning, Judge Clement, Judge McBrayer, Judge Bennett. This is a personal injury action, and in all personal injury actions, the medical causation must be addressed by a doctor, a medical doctor or a chiropractic doctor. In this case, we have three doctors. Dr. Lotfi, who speaks Arabic, and that was very helpful in treating and communicating with my client, Mr. Almuawi, and Dr. West and Dr. Willis, both orthopedic surgeons. So three doctors. Both Dr. Lotfi and Dr. West provided solid material evidence about causation for the shoulder injury. That's what is at issue in this trial, was the labral tear to Mr. Almuawi's right shoulder. So as I say, both Dr. Lotfi and Dr. West provided solid material evidence on causation that the car crash caused that labral tear to Mr. Almuawi's right shoulder. Dr. Lotfi, Dr. Willis did not have all the medical records. When I had called on behalf of the plaintiff, both Dr. Lotfi and Dr. West, the defense counsel called upon Dr. Willis. When defense counsel scheduled Dr. Willis' testimony, he did not present Dr. Willis with all of the complete set of Mr. Almuawi's medical records. I discovered that on cross-examination of Dr. Willis. And I asked Dr. Willis, do you think, he was seeing Mr. Almuawi for the first time 7 months after the crash, but there was a good bit of medical and chiropractic treatment that was conducted for Mr. Almuawi in that 7-month period that Dr. Willis was not aware of. And I asked him, I said, do you think that this is the first time it's, 7 months when Mr. Almuawi first comes to see you? That's the first time he's seeing a medical doctor? And he answered, and I quote, "That's my record. I mean, if he saw another medical doctor, aside from the ER visit, then I don't have that record." So when I learned that, I began to, in cross-examination of Dr. Willis, make him aware of showing him medical records that he hadn't yet seen, that showed, in particular, I showed him treatment records that established Mr. Almuawi was experiencing significant pain in his shoulder less than 1 month after the crash. I also showed him some photos showing the severity of the crash. And there was no, by all accounts, this was a very severe, hard impact crash. And then I asked Dr. Willis, forgive me for quoting here because this is critical. Is that of clinical significance to you for being able to determine that it's more likely than not that he did indeed suffer an injury to his shoulder from the car crash Answer: it's certainly much more reasonable seeing this. I mean, we could have saved a lot of time if you had given me this earlier, but seeing pain, 3-4 weeks, that's plausible for a traumatically induced labral tear. But again, this is the first time today that I've seen these records. So if you're asking, this is much more consistent with a labral tear that's acute at the time of an accident. Dr. Willis then continued, somebody who complains of pain in 3 or 4 weeks, a lot of shoulder pain, that is consistent with a traumatic labral tear, certainly from a high energy car accident, yes. The doctor continued, he had shoulder pain consistent with a labral tear after the accident. I can say that. And most importantly, Dr. Willis then testified as follows, quote, I'd say it's a lot more likely that it came from the car accident considering his complaints of shoulder pain, close quote.
And I trust this testimony was read to the jury.
Yes, Your Honor. The doctor's testimonies was by video, so it was the doctor testified just as I said by video to the jury.
So the jury had the benefit of knowing what you brought to the doctor's attention, that he had the pain within a few weeks of the car accident.
Yes, Your Honor.
Okay.
Again, the standard of proof in a personal injury action is more likely than not. The standard of proof is not beyond a reasonable doubt. Our Supreme Court
does the jury have to accept all an expert's testimony? Could they accept part of it and discount other parts of it?
It's my understanding, Judge McBrayer, that a jury can dismiss or disregard all expert testimony. That's what I heard Judge Brothers, that they can accept some or part or none of a witness's
Given
testimony.
that, couldn't an explanation for this verdict be that the jury simply did not accept Dr. Lotby and Dr. West causation testimony regarding the labral tear?
My point, Your Honor, on behalf of the plaintiff, is that all 3 doctors agreed that more likely than not, that the car crash caused the labral tear. All 3 doctors, both, not only the doctors that I called upon, Dr. Lotby and Dr. West, but even as I just quoted from Dr. Willis, whom the defense attorney called upon, even Dr. Willis, provided the proper standard, said it's a lot more likely that it came from the car accident, considering the complaints of shoulder pain. So all
again,
3
as
doctors,
you acknowledge, a jury's free to not accept a portion of an expert's testimony.
well, I go back to the fact that in a personal injury action, it's only through doctors that causation can be established. And all 3 doctors are agreeing that it's more likely than not that the trauma of the car crash caused the labral tear.
Well, are you suggesting then that the jury is bound when faced by unanimity by experts? The jury can still reject it, can't they?
Well, it's beyond all reason, and if we're just looking at what is material evidence, that's the basis here. Is there any material evidence? All the material evidence weighs in favor of the trauma of the car crash causing the labral tear. So there's not any material evidence to support otherwise, that it was not caused by the car crash. And that's the basis for appellate review. Is there any material evidence to support? And all the material evidence from all 3 doctors is that more likely than not, that this car crash caused the labral tear. Now, Dr. Willis did get stuck on this proper standard of proof. Dr. Willis was saying things like, I don't know that for sure. Or he said he needed to have a high degree of certainty. And quote, I can't look at you and say that that's definitely what happened. I submit to the court that those kinds of statements by Dr. Willis indicate that his thinking is that it's got to be a higher standard of proof, such as beyond a reasonable doubt. And our Supreme Court absolutely says that is not the standard of proof in a personal injury action. It's more likely than not. And Dr. Willis himself said it's more likely that it came from the car accident, considering his complaints of shoulder pain within less than a month of the crash.
But I'm assuming, since this was such a major component of your client's damage claim, that all these points were brought out in closing.
Yes, Your Honor. I appreciate the court's questions, and seeing that I've got 3 minutes remaining, I'm certainly glad to answer any other questions that any of the members of the court have. But
what specific evidence did the other 2 doctors present that you rely upon in seeking a verdict in favor of the plaintiff?
Well, I would simply say, Your Honor, that since the standard is there any material evidence supporting, I simply in my brief cited to the court where both of those doctors, both Dr. Lotfi and Dr. West, certainly testified that it's more likely than not that he suffered a labral tear because of the trauma of the car crash. And I've cited that in my brief. The standard on appellate review is there any material evidence to support otherwise? And so I focused upon if there was any otherwise, that is, if Dr. Willis gave any material evidence that said otherwise.
So your argument is that Dr. Willis did not testify that the labral tear was not caused by the accident. Thus, there's no material evidence to support a verdict that your client did not sustain a labral tear in the accident.
That's part of it. He absolutely did not. He absolutely did not say that it was not. He was more, as I pointed out at trial, using even the higher standard more as an agnostic. He at no point did he say that it was not caused by the car crash. And when I pointed out the proper standard of proof to Dr. Willis and showed him records that he hadn't yet seen during the direct examination, then he said, as I quoted, that it's more likely that it was caused by the car crash. So all the material evidence, forgive me if I'm belaboring it, all the material evidence from all 3 doctors was that it was more likely than not that the car crash caused the labral tear.
All right. Thank you, Mr. Dillon. Mr. Miller.
Good morning, Judge Clement, Judge McBrayer, and Judge Bennett. Corey Miller for the appellee, Antwan Gregory. I'm going to quote from Dr. Willis's deposition. That was the final thing that the jury heard from Dr. Willis was this testimony, and I'm quoting from his deposition. And one final thing, this is me talking. Is it still your opinion, within a reasonable degree of medical certainty, the labral tear that Mr. Almuawi does have, you can't testify that it is from the March 2017 car crash? Answer: I cannot testify within any degree of certainty that it came from the car crash based on the timing of my records and my exam and all the data I have in front of me. No.
Isn't that an erroneous standard of proof?
I think Dr. Willis may have got tripped up because if you
you set the stage by asking the question based upon that standard.
I asked within a reasonable degree of medical certainty, which is
why standard. Would you ask him a question that is based upon a standard of certainty that is improper?
I believe that the reasonable degree of medical certainty is the proper standard.
I don't think so. What about more likely than not? Isn't that what we've been hearing for 10 years now?
The preponderance of the evidence standard?
No, the doctors are to be asked, doctor, is it more likely than not that this happened or this existed or what, instead of a reasonable degree of medical certainty. Isn't that the new standard?
Your Honor, I do not know the answer to that question. I'd be happy to brief it at a later date.
Well,
I do not know the answer to that question. I apologize.
Obviously, John Day is not, we don't cite him as authority, but when I hear him speak at CLEs, he's almost rabid about that distinction.
Yes, Your Honor.
He may be wrong. Well, I'll have to look further myself.
Well, and I want to provide some context about why we called Dr. Willis. We did not retain any expert in this matter. Dr. Willis was a witness that was disclosed by the plaintiff, and it was actually the plaintiff who originally called Dr. Willis's deposition in January of 2019. If I may have my timing off, but we arrived at the deposition for Dr. Willis at Dr. Willis's office at TOA over in West Nashville. 15 minutes go by after the deposition was supposed to have started, and the deposition is then called off. And it came to our attention that the deposition was called off because Dr. Willis could not provide the testimony, the opinion that plaintiff wanted. So plaintiff goes to Dr. West, who then provides the opinion that plaintiff surely wanted. And it was only after that Dr. West was deposed that we made the decision to then take Dr. Willis's deposition about what transpired at his original deposition.
So Dr. Willis was a treating physician.
Yes, Dr. Willis did actually treat Mr. Almuawi.
Over what period of time and how many times did Dr. Willis see the plaintiff here?
It came out in his deposition that Dr. Willis only spent about 10 to 15 actual minutes with Mr. Almuawi.
And he first saw him 7 months after the accident?
Yes, Your Honor.
Okay.
But that is what I would consider key, because that's 10 or 15 minutes more than what Dr. West actually saw him. Dr. West never actually spent any time speaking or visiting with Mr. Almuawi. It was simply a records review, which is proper. Now, I'm not here to argue that that's improper, but that's still 10 to 15 minutes more than what Dr. West actually spent with him. But going on to the actual standard of why we're here, the goal, the standard is there any material evidence to support the jury's verdict? And aside from the testifying doctors, we would argue that there is ample evidence to support the jury's verdict. As the court has correctly noted, a jury can accept some, all, or none of an expert's testimony. They've heard the testimony of Dr. Willis, they've heard the testimony of Dr. Loppe, and they heard the testimony of Dr. West. They can choose, the jury can choose what to accept and what not to accept. That's their job. And clearly the jury accepted Dr. Willis's narrative of it over Dr. West and Dr. Loppe's, because it came back with a verdict of some $14,000 versus, because it clearly did not encompass the treatment from Royal Healthcare, which is a chiropractic clinic up in Chicago, and it did not encompass the labral tear. But there's more evidence than just that. You have.
Wait, the Royal Healthcare treatment did not involve care for the labral tear?
It did involve care for the labral tear with other care.
Was it all the care that the plaintiff received here on the labral tear from Royal Healthcare?
No, there was more care from Royal Healthcare that was more than just the labral tear. It is a chiropractic clinic that was involved more than just the labral tear.
Well, no, I don't think so. Did either Dr. Loppe or Dr. West treat the plaintiff here for labral tear?
No, Dr. West never treated the plaintiff. Dr. Willis never treated the plaintiff for the labral tear. Of course, he went there and saw him for 15 minutes, but I don't think he actually provided any treatment other than examination. And then Dr. Loppe is the chiropractor, and I believe he is a physical therapist as well up in Chicago. And A little background: Mr. Almuawi was down here in Tennessee going to school at TSU, and in the midst of this, his wife ended up being admitted to a graduate program up in the Chicago area. So he would travel from Nashville to Chicago every weekend, I believe. And at that time was when he would treat with Royal Healthcare. So he stopped treating here in Nashville about a couple months after the accident and treated pretty much exclusively at Royal Healthcare thereafter.
I see.
So we would turn to other evidence supporting the award. We would note that there was a stop of treatment on May 3rd, 2017, and there was a gap between May 3rd, 2017 until about 2 months after that, which was when Mr. Almuawi started treating at Royal Healthcare. In the initial records on the day of the accident, there's no mention of any shoulder pain whatsoever. And it's only about 4 weeks after the accident, 3 to 4 weeks after the accident, there's a mention of shoulder pain in the records. So he stops treating, and then he starts treating at Royal Healthcare. There's no mention of any record for about 3 to 4 weeks about shoulder pain. And then the deposition of Saad Al-Qahtani, who is the friend who came and picked up Mr. Almuawi at the scene of the accident, and the deposition of Mr. Almuawi's wife, Mora Almuawi, was also taken by the plaintiff. Mrs. Almuawi testified about some sort of support for his arm immediately on the day of the accident, but there's no record or medical bill of anything being prescribed to him for some sort of support. And you can see in the video, and there's a language barrier because English is not her first language, and I certainly don't speak Arabic. So we were trying to communicate clearly, but there was clearly a language barrier. She makes this hand motion around her neck. She makes this hand, she never mentions the word neck, she never mentions the word brace, but she makes this hand motion as if to say it's a sling to support his arm. I asked her if it was a sling. I don't think she understood what I was asking, but she said no. Nevertheless, she gives that testimony, and the jury heard that testimony, but there's no record of any sort of support or any sort of brace or anything for the arm. Mr. Al-Qahtani, who was actually with Mr. Almuawi on the day of the accident, he never mentions anything about any sort of support or brace or anything to support his arm. So you have these key material evidence. You have this key material evidence that clearly supports the jury's verdict. You have the jury decided, if it didn't want to accept some of Dr. Loppy's testimony, some of Dr. West's testimony, some of Dr. Willis's testimony, that's its prerogative. And our position is that if Mr. Almuawi thought Dr. Willis's testimony was so flawed that it shouldn't have been presented, that the jury should not have considered it, and that should have been handled in a pretrial motion in limine, which was not done, and that's his prerogative. But it wasn't done, and now is not the time to do it. You can't do it after the fact. Is there
any evidence that the plaintiff sought medical care for the torn labrum or that shoulder injury earlier than 7 months after the accident?
Yes, there is. There's I believe it was the 3 to 4 weeks. He's going to a physical therapist, and it was about 3 to 4 weeks after the accident, which is when the first mention of any sort of labral tear is mentioned in any medical record that's within the record that we've certainly seen. If there's a medical record out there that says something sooner, it's not been brought to anybody's attention.
And when did he first seek medical care from a physician?
The day of. He went to the emergency room. Okay. And the jury awarded, and we actually told the jury at trial that the jury should award him damages. We implored the jury to award him $8,257.21 in medical expenses. The jury also awarded him $539 in property damage, which was the glasses. None of that was disputed. We told the jury award that to him because that's what our position was caused by the accident. And then, of course, the jury awarded him non-economic damages in $2,500 in pain and suffering, and then $2,500 in loss of enjoyment of life, for a total of $5,000 non-economic damages. But that's our position, was that was all that was caused by the accident. And that's all that was proven at trial. And that's all the jury accepted. And the trial court has, agreed with the jury's verdict twice now, when it signed the order of judgment and entered it in with the court. And when it denied the plaintiff's motion for a new trial, it agreed with the jury's verdict.
So your position is the jury did conclude that he suffered an injury. They
Yes.
compensated him for that injury. And there's not material evidence to overturn the jury's determination as to the amount.
Well, our position is that there's material evidence to support the jury's verdict.
Correct.
Yeah.
I'm sorry.
And the standard is any, not ample. It's any, meaning if there's a shred of material evidence to support the jury's verdict, then it must stand.
You're absolutely right. I misstated it.
So our position is that this was, I agree with Mr. Dillon. This was a hard car crash. The photographs don't lie there. And this was a case of admitted liability. We admitted liability. We did not make Mr. Dillon prove liability before the jury, because there was nothing we could do. It was clearly our client's fault. But I'm going to quote Judge Binkley. I was before him a couple weeks ago, and he said, sometimes hard crashes result in no injury, and sometimes soft crashes result in significant injury. And just because a hard car crash is evident, that does not mean that it caused the labral tear. And so we would submit that this jury's verdict was adequate to compensate the Mr. Almuawi, and there's ample evidence, in our opinion, that to support that verdict. And I'll be happy to turn it over to the court to answer any questions that you may have.
Hearing none, thank you, Mr. Miller. We'll hear rebuttal from Mr. Dillon.
Thank you, Your Honor. Dr. Lofty, just to try to set the record clear on a couple of points that Mr. Miller has said, Dr. Lofty was a treating doctor. He didn't treat him much, but he did treat him. He saw him himself twice. He's the one who ordered the MRI, which confirmed the labral tear, and he prescribed physical therapy for Mr. Almuawi. The chiropractor in Chicago, in Illinois, the chiropractor is not only licensed as a chiropractor, but also as a physical therapist. So he was able to do the physical therapy that Dr. Willis prescribed. Also, in terms of a gap of treatment, there was no gap in treatment. It was just a gap here in the United States. My client is from Saudi Arabia, and there had been a long scheduled trip for him and his wife and children to return to Saudi Arabia during that summertime. So that was there's not a gap of treatment. He received treatment there, but we didn't have medical records from Saudi Arabia. Again, I'd say with the few seconds remaining that allowed for the plaintiff's rebuttal here, is that all the material that a medical doctor is required to address causation. All three medical doctors, when they were using the proper standard of more likely than not, all three medical doctors agreed that the crash more likely than not caused the labral tear. So all the material evidence is in that favor, and there's no material evidence to support otherwise. Thank you.
Thank you both for your arguments. We will take the case under advisement. Mr. Hibner.
The Honorable Court is now in recess until 10 a.m.
All right, counsel.